Okay. So, before the class regarding the PMTs, first one is be on time. Second is regarding some concerns that the paper is lengthy, half an hour is not sufficient. Half an hour is sufficient because most of the questions you don't know. So that is also I want to say. See, after 1 or 2 PMTs, you will think that I don't know the answers. Should I give the PMT or should I study? So let me make it very clear here. You give the PMTs. Two things will happen. Whatever you are able to recollect, you will try to recollect and eliminate and solve. Second, there is no such pressure. Only 20 toppers' names will be listed outside. So there is absolutely no such pressure that okay, my name is not there. Most of the people's name won't be there. But you need to give the PMTs because then only you will get acquainted with a set of questions. So by the time we complete our phase 1, that is why March, before March, like between March 15 to 20, you might have completed almost whatever is relevant from the current affairs perspective and otherwise in just another 45 days. If you think that I will study first, then both won't happen. You won't study also, you won't do test also. You will keep on postponing it. You will think that there are 5 months. Let me study 15 days polity, next 15 days economy, like that, or whatever be your general strategy, which we are seeing for the past so many years. That is why I am saying it. So don't deviate from your strategy of giving PMTs. Even if you are not able to solve, you do read the PMTs as there are certain pattern change. That is also intentional. Because you will start applying your knowledge. That is why intentionally there are certain pattern changes introduced. Just to make sure that you are able to apply your knowledge. So do give PMT without even missing one PMT. You should do all PMTs. So that is my request, and I am telling this to you as my brothers and sisters, not just as like some aspirant sitting in front of me. If if my brother or sister is sitting, same thing I'll tell. Even if you didn't study, you just go and give the PMTs, because something you will be knowing, something you will remember, something you will eliminate, a process will happen. Next, another student came and said that how to revise. Please explain how to revise. How to revise? Tell me. You take your notes and read 2-3 times. No, it's a very genuine question. What I am saying is that revision is important, repetition is important. So instead of looking for so many sources, at least from current affairs point of view, for example, for static topics, you are already having some books which generally aspirants use. But the problem is, with respect to current affairs, there is no standard book or there is no basic reading material. So you will keep on hopping from one magazine to another magazine or one study material to another study material, and you are all having access to something which is called as what? Yeah. And you will keep on getting some study material, so you will think that, okay, let me read that also, let me read this also. My humble opinion is that whatever you are reading, you should be in a position to read at least once or twice again. If not, don't touch it. Because the problem in PT will be accuracy. You will remember, I know something about it. I know digital access is 19 or 21. Last class I do read that, I heard that, but I did not revise that. Then you will make a mistake and you will mark all 4, all 5. And after 2, 3, all 4 and all 5, you will think that now I will mark all C. Anyway, it is not in my hand. Or all B. Generally UPSC goes for B or C. Like that you will start coming with your own ideas, defensive mechanisms. So please do revise whatever you are doing. You ensure that you are having time to revise that once again. That is very important. Second, we are also giving a recall worksheet. The idea is that to ensure that you are revising it and then you are solving it. So these are the 2 methods I request you to adopt to revise that instead of hopping for different materials. Because in class also we are covering topics plus PMTs are there. Every PMT is 25 topics. 25 plus topics, not even 25. Generally that is the nature of UPSC also. If you think that it is 100 questions, it's not 100 questions, it is 400 questions. So that is the same thing. If it is 25 questions, no, it will be 100 questions. You need to know at least 100 different areas to solve a 25 question. So with that, it will serve your purpose, because around maybe like 40 to 50% at the max, 45% questions are directly coming from current affairs. It changes, it varies. But you cannot neglect this area. That is the most important aspect of current affairs. So I request you to give PMTs, revise that, then solve the recall worksheet. So that is it. Okay. So let us continue with the topics, pending topics. First one is Promotion and Regulation of Online Gaming Act 2025. So this also I said in last class. Important acts in news. So UPSC generally asks one question or 1 or 2 questions from important acts in news. So we are trying to cover some acts which is relevant in that areas. For example, fundamental rights, some areas, some new acts are there which is relevant in that fundamental area that we are covering. Separately, important acts we will cover. So first point is that it is related to online games or online gaming. So first is the constitutional nuances. So India, traditionally, constitution as well as the courts protected game of skill. Game of skill is protected, but game of chance is considered as gambling, which is not protected. Constitutionally, it is not protected. So gambling and betting is under state list. Since gambling and betting is under state list, there are different laws or there is no uniform law. In India, there is no single law related to prevention of gambling and betting. So there are different state laws which prohibits gambling and betting, or some states which also allow some kind of gambling. So that is the scenario, that used to be the scenario. So this is protected. So how judiciary interpreted game of skill, that it is protected under Article 19 1A, 19 1G and 21. So that is the first thing, it is protected under Article 19 1A, that is expression, game is a facet of expression. Then 19 1G, that is profession. It is also protects profession, occupation, that is 19 1G. Third one is Article 21, that is right to life and personal liberty, that also includes right to play games and sports. So this is the constitutional protection. Why? Because game of skill requires some kind of knowledge or skill, and its outcome is dependent on this experience, knowledge or skill. So game of skills outcome is dependent on certain knowledge you are having in that sports, or the skill or the experience or the strategy. So since there is, the outcome is dependent on these things, it is protected. But game of chance, the outcome is purely luck, random. Since it is purely luck or random, it is not protected. But what was the problem? The problem was there was a lot of issues of misuse of a lack of uniform law. There was issues of financial stakes involved, and thereby leading to even suicides because of huge debt burden. And there is also problem of addiction. So central government recently introduced promotion and regulation of online. So both are there. So it is like a traffic light. Promotion is there and regulation is there. So what is the key aspect? A complete prohibition, a complete ban on online money games. And it is also important to know what is the way the law defines online money games. Online money games are any games regardless of skill, any game if it involves a financial stake. That is a trap, MCQ trap. So regardless of skill, if that involves a money and the reward also involves a money, then it is considered as gambling, or then it is considered as an online money games. So it is not directly linked with a skill or anything else. You are participating with the money, and what is the thing you are looking for, that is also money. That doesn't mean that if you are getting money from a sport event, that will be considered as an online money game, because certain games are promoted, that is e-sports, because these are competitive sports. You may get money, but these are competitive sports. You are participating not for that money, because of your interest or skill or your genuine part of your expression you are participating it. So e-sports is promoted, for example e-FIFA. So that's a competitive sports. So such a competitive sports are promoted. It is also regulated. These sports are regulated. There are bodies which regulates that. Similarly, so this is the first one, online money games. This is also called as RMG, that is real money games or online money games. But what is promoted is esports. What is completely banned, that is traffic light model, red light. A complete ban if it is online and you are participating with the money, and why you are participating, that is also for financial stake money. There is also another thing, online social games. Online social games. These online social games are basically games that are played for fun. Games that are played for fun. So that is not for any money sake. You are having enough time because you are preparing for UPSC. So you are playing Candy Crush 24 hours. So that is something government is saying that khelo. As long as you want, stress, to make you stress free, whatever. Okay, so that is online social games where the objective or aim is not any financial stake or any money element. Just for the social aspect you are playing. That is also not prohibited. Second, so this is the first key provision which are promoted and which are regulated. What is the trap here? If financial stake is involved for participating as well as reward, whether there, for example, the Dream 11, it is now banned. The problem is what? There is actually skill involved. You need to know something, but still government says that the main aim is not that. The main aim is, yeah, anyway PT is not working, let me make some money and satisfy my parents. So that is the aim. So that is the problem. Okay. Second is, there is a need of an authority. So an authority is established, that is Online Gaming Authority of India. Online Gaming Authority of India. Online Gaming Authority of India. So this will be a regulatory body at the national level, and it will be established, this body will be established to categorize the games, maintain a registry of allowed games. This will also maintain a registry of the games which are allowed, permitted, and also address the grievances. So first point is an absolute prohibition of online money games. Second is establishment of a regulatory authority, that is Online Gaming Authority of India. That is a regulatory body established to categorize games, maintain a registry of allowed games, and address the grievances of the people who are involved in such games. Third one is, there is also a proper grievance redressal model. Grievance redressal model. So that grievance redressal model provides a 3-tier mechanism. 3-tier mechanism. So the first level is, first level, that is internal grievance redressal mechanism by the provider, that is a game provider. By the game provider. Second is, there will be a grievance appellate committee, established under IT rules. So that same committee will be applicable for here also. So this act is plug in that same mechanism. There is a grievance appellate committee established under IT rules, and then top comes, yeah, OGAI, the real OG. Okay, so this is the mechanism, a 3-tier grievance redressal mechanism, and it also provides, as usually, it also provides stringent penalties. Strict penalties for violations of the provisions, including jail term. Means there is strict penalties, strict punishment. You can come. Okay, so these are the key things with respect to this topic. Next is, so the key trap here is, now see, betting and gambling is in the state list. Here it is basically talking about what? Online games. So online games promoting, regulating everything. See, some things are not, if it is not under any of the list, then automatically the power will go to center. Reward? So that is what I am saying. So this authority will keep a registry of the allowed games. Allowed games. For example, esports, there are certain sports which are recognized as esports, which is regulated by bodies. So these are even FIFA, chess is there, which is also an esports, which is also online. So those which are allowed, so this body will maintain a registry. So those will be considered as allowed, and others which are mainly for purely for the money stake or only for the financial aspect, it may not be considered as online, what you call esports. So this body will keep a registry of those things, which are the sports which are allowed, and they will come up with a regulation. Or if there is a regulatory body which comes up with a esports, that will be approved by the government. This is the OG. Okay. So that is it. So the traps possibilities are mainly, one is the constitutional aspect, because polity question will come from this dimension also. Which of the following articles are covered under the protection of game of skill? And it will give 3-4 articles, 15, 16, and you will mark 16, 15 and 17. Untouchability game, there should not be any untouchability and all. And then you will come out and you will challenge UPSC. Why? How come you can allow untouchability in games? That generally happens those who are working on this online social games most of the time. Next is, we are moving to another part of Article 19, that is cooperatives. Actually, this is a pending topic. UPSC any day can ask a question both in mains and PT, especially when the present government is focusing on this particular sector, cooperative sector. So, cooperatives, first of all, in order to understand this, you need to know 1C, or in general, Article 19, freedom of speech and expression. So, 1A talks about freedom of speech and expression. Then 1B, it talks about assembly. 1C, it talks about association, union. This was the original constitution. But later, another word, cooperatives, is inserted to 191C through 97th Constitutional Amendment Act. Through 97th Constitutional Amendment Act, I think 2011, this was inserted the third term, that is cooperatives. So why government want to introduce cooperatives if there is already a fundamental rights to form association or union is already there? So what is the meaning of right to form association, or what is the meaning of association? Yes, Roshni will tell. What is the meaning of association? Very good. So association is in a general term. It can be anything. It's a political association, a residential welfare association, or two people can be an association. This particular meaning is used by the court, Supreme Court, in which case? Which case? Right to silence. Okay. It is in Special Marriage Act case, where the then Chief Justice Justice Chandrachud said that, okay, right to form association also include two people can form an association. Can we give some recognition to that sort of association instead of giving recognition through Special Marriage Act for same sex couples? So association include anything. It is a very general term. But the next term that is also in the constitution, that is union. So what is the difference here? Union is a legal entity. Union is a legal entity. So when you talk about union, it is also a form of association. But what is the basic difference? There should be it requires a legal sanctity, trade union. And what is the main idea here? The main idea here is collective bargaining. Collective bargaining. So association and union, there is a difference. But Parliament not only use this word to give some protection to cooperatives, it also introduced another specific term, that is fundamental right to form cooperatives. Why government introduced this, or why Parliament introduced this? Because it is cooperatives. What is the basic idea of cooperatives? It is an economic welfare organization. It is an economic welfare is the basic aspect. The objective behind cooperatives is economic welfare. So compared to association, compared to union, government gave that citizens are having a fundamental right to form cooperatives, which means Indians are having a fundamental right to form an economic welfare organization where the focus is basically what? Economic welfare. Compared to union or compared to association, there is a difference. That is why that term is introduced, cooperatives. Not only the 97th Amendment Act also introduced or also inserted some other provisions, that is 43B. 43B in the Constitution, which basically DPSP, which says that states should actively promote cooperatives. Promotion of cooperatives. Then it also introduced part 9B, that is basically for cooperative governance. Cooperative governance. Part 9B also introduced through the 97th Amendment Act, which basically talks about cooperative governance. Now, in the case of cooperatives, another key aspect is that it is part of Entry 32 of state list. Cooperatives, the word cooperatives is part of Entry 32 of state list. So it is governed by respective state cooperative society acts or states. But Entry 44 of union list basically governs the multi-state cooperatives. Cooperatives which are in more than one state, multi-state cooperatives. So that is being governed by the union law, or for example Multi-State Cooperatives Act. So the fundamental difference between state cooperatives and multi-state like union or multi-state cooperatives is the geographical scope. Geographical scope is the fundamental difference. So those societies whose activities are confined to a single state, that will be regulated by the State Cooperatives Act. But if geographical scope is wider, if it is in multiple states, then it will be regulated by union government, that is through Multi-State Cooperatives Act. Next is another key aspect of this topic is UNGA. UNGA adopted year 2025 as the International Year of Cooperatives. This is also a trap point. Of late UPSC started this kind of habit of changing year and all. Previously that was not there. Now UPSC understood that all are in either in online money games or online social games. we can even trap them by making change in the year. So that is important. It is not 2026, it is 2025. UNGA adopted a resolution to celebrate year 2025 as International Year of Cooperatives. It is moved by India. So that is another aspect. Next one is, it is also in news because of National Cooperative Policy. National Cooperative Policy. Now even a question can come from just National Cooperative Policy. National Cooperative Policy. You can expect this question, like even in mains, this cooperative sector is important this year. So what is important is you study for the next 5 months, clear PT, again study for another 3 months. Wonderful life. So those who don't want to study after May, if you think that, okay, I want to study only for the next 5 months, options are there, online social games. So National Cooperative Policy 2025, it is important because it is the second such policy introduced by the government. That means first policy was in 2002. The first policy was in 2002. Second such policy is introduced now, that is National Cooperative Policy. It is unveiled by Ministry of Cooperation, and its vision is Sahakar se Samriddhi. Prosperity through cooperation. So that is the vision, and its strategy is for next 20 years. That is also a trap, pure factual trap. That is for next 20 years, that is up to 2034. Now if you know that, okay, it is a policy unveiled in 2025, you also know that it is for 20 years, you may end up thinking that it is up to 2030, 2045. So it is basically for a period of, it is basically only for a period of 2030 for whatever is given now, just for a period of 10 years. Now it is the first key aspect of this particular strategy is that it will increase the key aspects of this strategy is that it will increase cooperative sector's contribution to GDP. Cooperative sector's contribution to GDP by threefold. According to various estimates, there is no concrete data on these things. Presently, the cooperative sector's contribution to GDP is around 3 to 4%. So there is no clear estimate and all. So the idea is to increase the contribution to like threefold. Next is, it also planned to establish at least one cooperative society in every village. One cooperative society in every village. Next is, it increased the overall participation. To increase overall participation, it was planned to bring around 50 crore Indians into the fold of active cooperative participation. Majority of the Indians it want to bring into the fold of cooperatives, and also geographical expansion other than the present stronghold like Gujarat, Maharashtra, Kerala, etc. It want to further expand the geographical areas network beyond the present stronghold like Gujarat, Maharashtra, Kerala and all, especially into states of Uttar Pradesh, Bihar and all. So that is also another key aspect. Okay. Which one? Yeah. It will be. The idea will be, it will be PSC through primary cooperative societies. That will take up in economic class also, primary cooperative societies, urban cooperative societies and all. So next is there is also a plan to increase or expand its area into non-traditional areas of cooperatives. Non-traditional areas of cooperatives like services, various services, including tourism or even taxi services, Sahakar taxi, tourism. So expand the areas into new areas, especially tourism or taxi or such areas. Similarly, renewable energy, green energy, participation of cooperatives in transition into green energy, renewable energy. Okay, and there is also a university, that is Tribhuvan Sahakari University. It will be a national level cooperative university established in Gujarat. It is to provide professional training and capacity building. Professional training and capacity building. So here the main trap is, one is you need to know the amendment. Sometimes just match the following will come. Match the following will come like 97, 100, 101, 102, 103. So that is one thing. Second is the constitutional amendments and what are the articles inserted, parts inserted. Third one is year, that is another trap area. Fourth one is national cooperative policy. You please remember at least the key aspects whatever we discussed so that you can eliminate. There are many things like pillars are there and all, but at least you remember this much. That is enough. Plus the state list and union list. Next is narco test. So now we are moving to next, that is Article 20 of the Constitution, that is about protection in respect of conviction for offences. So this is another area, another article which is significant. So it's an important fundamental right that prevent any arbitrary punishment that can be given by the state. So this article is also related to what? Criminal laws. It is mainly safeguarding against criminal laws, and it can be asserted by any applicability. What is applicability? Any person. Applicable to any person, not just citizens, to any person. So what are the set of rights guaranteed under Article 20, first one, 20 clause 1. What is Article? It is about no ex post facto criminal legislation. Criminal legislation should not be enacted ex post facto or retrospective effect. You know these things. Second, 20 clause 2. No double jeopardy. So that is another thing. Third one is, this is what is important for us, no self incrimination. So first one is no ex post facto legislation, second one is no double jeopardy, third one is no self incrimination. You cannot be a witness to your own offense or case, and this is mainly related to what we discussed, criminal offense. So what is the key aspect here is regarding narco test. So recently it was in news because Supreme Court in a case that is known as Amlesh Kumar versus State of Bihar case. Amlesh Kumar versus State of Bihar case, Supreme Court ruled that, again reiterated that any forced or involuntary narco test is unconstitutional. Supreme Court reiterated this ruling that any forced or involuntary narco test is unconstitutional. So that means compelling such a test without free consent. That is the idea. This is very important. Free consent. Forceful or compulsion without free consent violates fundamental rights. This basically Supreme Court reiterated the Selvi principle. Selvi principle. That is Selvi versus State of Karnataka, through which court come up with Selvi principle. Supreme Court just reiterated the Selvi principle. What is Selvi principle? If there is a narco test, which all article it will violate? 20? Very good. 20 clause 3. It also violates 21. So that is basically Selvi principle. So Selvi principle, Supreme Court held that forceful administration of narco test violates article 20 clause 3 and 21. Narco test violates article 20 clause 3, that is right against self-incrimination. You cannot be compelled to be witness of your own or against yourself. Similarly, 21, right to life, because forcing a chemical into someone's body without his free consent goes against his mental privacy or his dignity, physical dignity. So that is also included, both 20 clause 3 and 21, that is Selvi principle. So this is reiterated in the recent case because narco test is basically a medical procedure not to heal but to reveal. Not to heal. The intention is not healing some disease, but to reveal or extract information. So it is an interrogation technique. And here the suspect is injected with a psychoactive drug, and the drug is basically sodium pentothal. So Supreme Court, not Supreme Court, what we are discussing? Yeah, it's a medical procedure not to heal but to reveal or extract information by injecting a hypnotic or psychoactive drug, which is basically called as truth serum. Truth serum, and one major such truth serum is sodium pentothal, pentothal. So pentothal, so that is basically truth serum, so that is being injected. So this is considered If it is forceful or involuntary, it is considered as an act of self-incrimination because you loses your reasoning power. It is like some YouTube channels. It will affect your reasoning power and you will completely lose your ability and you will get manipulated. You will think that everything is true or you will say whatever. So it is kind of, now if in the question the truth serum is YouTube, then don't write that as a right answer. It is sodium pentothal. Okay, so that is the key aspect. It is also another key thing is, so that is the chemical used. Another key aspect is that these are part of what? Deception test. Deception detection test. These are all part of deception detection test. Deception detection test. Now one more thing is there. So narco analysis, brain mapping, all these are, Supreme Court put a restriction. What is that? It should be based on free consent. But what about normal blood test or DNA test and all? Yeah. So you cannot use 20 clause 3 to deny your consent to DNA test or blood test. So these are not considered as self-incrimination. These are not considered as self-incrimination. So individual shall subject herself to such blood test or cooperate with such any DNA test with the authorities, or like thumb impression. You are giving thumb impression to anyone. Why can't you give to police? But what is another thing is that Supreme Court many times held that such things, such reports are not admissible in a court of law. Means the report you are getting from narco test or brain mapping, all these things, these are not admissible in a court of law, even if it is done voluntarily. Even if it is done voluntarily, because a person during trance cannot be considered as saying something. He is in trance, right? Okay. So some people will just allow because they want to be in that trance. 2-3 tests you take. So even if it is done, that is a point, that is a trap point. So even if a test done voluntarily, statement made by a person during such state of mind cannot be used as a direct evidence in court. There is also one more catch, direct evidence. So 2 traps are here. One is it should be based on free consent or voluntary. But even if it is voluntary, it is not admissible in court of law. What? As a direct evidence. But if that admission is leading to recovery of something, because in the trance mode you said that I kept the Lakshmikant in that library, and the police went and saw the Lakshmikant in the library, then that is an evidence which is admissible. That evidence is admissible. So it is the Supreme Court basically put such restrictions on that. It is not the Evidence Act per se. Supreme Court put such restrictions and say that this is not admissible because it is not free consent. Since it is not free consent, it goes against 21 and also it will lead to self-incrimination. So violates Article 20 clause 3. Okay. So that is the trap point. But if the test reveal new facts, recoveries, then it is unconsidered. If some recovery happens or it reveals some new things which is useful for investigation, those things can be considered. But what happened is that Patna High Court allowed narco test on all accused. Kar do sabko. And even witness, everybody. So all a group of people are in trance. Bihar is? Bihar is? Not for Indians, okay. Not for beginners, okay. Sir. Bihar is not for beginners, okay. Total India is not for beginners. We are on a different trance without any narco test. We can't do anything. So next is, it is admissible. You need to give consent also. You need to cooperate with a blood test or DNA test. Next is, what is the next topic? Privileged communication. In Bihar only that this came, no? Hey Prabhu, that is from Hey Jagannath. Orissa, okay. Anything can be viral from such things, okay. So next is article, we are moving to next 19, 20 and 21 now. No, privileged communication, okay, that is also part of that. Then we'll move to 21. This also comes under 20 and all. So privileged communication. So this was in news because police issued a notice to a defense lawyer and demanded that the lawyer should appear to share the information regarding the client. That is what India is not for beginners. Police is not having time, that is the thing. So you just call the lawyer directly and say that tell the details so that we can arrest that person. that is the model. So after IPS, some of you will become IPS in the coming year. So what you will do? Call the lawyer directly and tell, okay, reveal the details and say, sir, I close the case. How? Directly call the lawyer and did it, sir, in one day. What? Crack jokes, tell. So next is, so that is that. So the problem is that if you are in legal trouble and you will tell the truth to the lawyer and lawyer reveals that everything to the police. What an idea, Sirji. This is what happened. Okay. So Supreme Court said that a lawyer cannot be forced to reveal what a client told them in confidence. This is privileged communication. This is privileged communication. A lawyer cannot be forced to reveal what a client told them in confidence. That is privileged communication. So privileged communication basically refers to the confidential conversations between people in a specific protected relationship. That the law keeps secret. So what are these specific protected relationship? We'll see. See, the basic objective of such privileged communication is to protect the trust, because if people cannot speak honestly, they cannot reveal the truth honestly to the lawyers or their spouses, matrimonial confidentialities, and if they think that everything police will listen, after marriage you think that whatever I say to this guy or this girl will go to police. So no communication through WhatsApp, nothing, only through Telegram in another person's name. So that is protected relationship, that The goal is basically to protect trust without the fear of police or to ensure fair trial. That is also a constitutional right. And these protections are found in section 128 to 134. (128) to 134 of Bharatiya Sakshya Adhiniyam, BSA. There was a cycle in the past, BSA cycle, BSA SLR. You will be not knowing. You are all Gen Zs, right? Anyone for 80s and 90s here? 70s? 70s? You are sitting on behalf of your children. They are saying this, I cannot sit for 3 hours, you go and sit. So father and... Okay, speak. I thought 70s I asked, you suddenly got up, parents are leaving. So 128 to 134 of the Constitution, BSA, it talks about these kind of protections. First one is section 132. You don't need to know exactly, but still you remember. Sometimes if I told you the following is coming. Attorney-client privilege, lawyer-client privilege. That is section 132. Sorry, don't make the mistake. 132 of Bharatiya Sakshya Adhiniyam, section 132. So this protects communication between lawyer and their client, that is privileged communication. And under this, an advocate is prohibited from disclosing a communication made to him by the client to the authorities or such law enforcement agencies. But there are certain exceptions. Exceptions. First one is consent. If the client agrees, to the disclosure, then it is allowed, means it is not compulsion. Second one is if there is communication, if it is leading some illegal purpose, if that communication was made to further an illegal purpose, so to do some future crime or some illegal purpose. Third is if the lawyer observes a crime during his employment or during that partnership relationship, the lawyer observes a crime. So in these situations, this is not considered as a privileged communication, you can reveal that. Okay. So that is one major privileged communication, lawyer-client. And not only that, Supreme Court also said that the role of a lawyer in such situation, the role of an advocate or lawyer is a constitutional actor. He is a constitutional actor. He is having some constitutional obligations. He is having something to protect, which also important for as a protector of the constitution. So he is a constitutional actor. Advocate or lawyer is not a private agent but a constitutional actor. Now this particular confidentiality, such communication is deeply rooted in the constitution. First one is 20 clause 3, because if you reveal something to the advocate and the police is forcing the advocate to reveal that, then it is an indirect way of taking the information. There you are actually acting as what? Self-incrimination. So 20 clause 3, that is first thing. Second, a fair trial is also part of right to life, Article 21. Article 21, fair trial. So without a confidential legal advice, a fair trial is impossible. Then there is also a right to legal counsel under 22. Right to legal counsel under 22. So if this right is meaningless, if there is no confidentiality, right to legal counsel under Article 22. And it also important to ensure right to equality. Article 14. How? So if the police is getting such information, then the judicial balance will tilt towards state, that is inequality. If police is getting such information, not through a direct means, but through such information, through such lawyer or something, then the judicial, there is no level playing field, then it's arbitrary. That is against equality. So it also violates equality if there is state arbitrarily intrudes into such things and the judicial balance tilt away from the client towards the state. Other type of privilege communication is spousal privilege. Spousal privilege, that is matrimonial relationship. Spousal privilege, that is also considered as a privilege communication. You cannot force or compel the spouse, like husband or wife, to reveal some information during their marriage, whatever they said during their marriage. But if the marriage is broken, nowadays court is taking into consideration the WhatsApp messages also. If somebody is like, court previously said that you cannot cheat and like take the WhatsApp messages of one person sent to another or something. There will be trilateral relationship. So that is possible. So such cases you cannot submit, that may not be considered because it is privilege communication. But nowadays court is saying that okay, bring that WhatsApp chat, we will take it if it is broken. Okay. Third one is state privilege. State privilege, that is official records, unpublished official records cannot be disclosed without permission. Unpublished official records relating to state affairs cannot be disclosed. Without permission. So this is to protect the national interest. It is also an important privileged communication. So these are the things. So here catch is basically the constitutional nuances 14, 20 clause 3, 21 and 22. Next is we are moving to 21, that is right to life and personal liberty. Right to life and personal liberty. So this is the fundamental right which is given the widest possible interpretation by the Supreme Court. So that is why we discussed that previously. It was believed that the rights are basically gifts of law, or the source of the rights are basically coming from Constitution. But now it is recognized that the rights are inherent to us like human being, and Constitution or Supreme Court or judiciary is recognizing the inherent rights. Inherent rights. So that is how the interpretation is widened, especially under right to life and personal liberty. So right to life and personal liberty, or Article 21 says that no person, again applicability is to person, no person shall be deprived of his life and personal liberty except, so what is the exception? What is the, what is the, it is also not an absolute right. What is the reasonable restriction? Except in accordance with the procedure established by law. So I hope everybody knows the difference between procedure established by law and due process of law and all. What is the difference? Arbitrary, executive action, and this is Legislative action. Which is closer to natural rights? Question previously came, that is why you know, right? Most of them that time answered like it is procedure established by law. So what is the basic difference? Procedure established by law and due process of law. Here the procedure needs to be fair, just and reasonable. Here not only the procedure but also law needs to be fair, just and reasonable. That is the difference. Simple. So procedure PL versus DPL, here the procedure needs to be fair, just and reasonable. Law or legislative action is not covered. Executive action is covered. But here legislative action is also covered. So court will also see whether the law itself is fair, just and reasonable. Okay. So that is simple. Now Article 21, what we are discussing is right to privacy. One topic in the last few years, especially after the Puttaswamy case, repeated in PT is right to privacy. From the fundamental rights, a question, if it is repeated, that is right to privacy. So what is the basic meaning of right to privacy? It is right to be let alone or no unnecessary interference in personal life of individual. So this right is recognized as a fundamental right in Justice K.S. Puttaswamy case 2017. So in this case, Supreme Court said that right to privacy is an intrinsic part of Article 21 and other parts of the Part 3 of the Constitution. This is the exact statement. Right to privacy is intrinsic to Article 21 of the Constitution and other parts of Part 3 of the Constitution, which include maybe 19 and all. That also included. So that is exact judgment by the court in Justice K.S. Puttaswamy case, where Supreme Court recognized that Indians enjoy right to privacy, you know that. But it is also not absolute. Before that there are different dimensions of right to privacy. First one is, what are the major dimensions? Spatial privacy, spatial privacy. Second one is decisional privacy. Third one is informational privacy. Spatial, decisional and informational privacy. So a state cannot intrude into a person's home without the authority of law. That is spatial privacy. Or autonomy of an individual, will, decisions, sexual identity, gender equality, that is decisional autonomy, decisional privacy. Third one is informational privacy, that is data protection. These are the three major dimensions of right to privacy. But there are limitations. Right to privacy is also not absolute. State can impose restrictions if it meets certain criteria. What are these? If there is a law. Second is legitimate state interest. Third one is proportionality. If there is an existence of a law which allows intrusion or which allows state to invade or enter into the private affairs, if there is a law, then if there is a legitimate state interest, if it's a compelling state interest to provide maybe some public services or some benefits or subsidies or something, government services. Third one, it should be proportional. The intrusion needs to be proportional to the objective sought to be achieved. Internet shutdown sometimes is considered as not proportional. If you are banning internet throughout the state to prevent some law and order issue, then it is not considered as proportional. Okay, so that is right to privacy. From that follows, after this only, Justice Sri Krishna Commission was constituted to draft a data protection law. Finally, a data protection, digital protection, what is that? DPDP? Digital Personal Data, what is it? Yeah, Digital Personal Data Protection Act was enacted. And now it is in news because of it, rules to implement the Data Protection Act. Rules to implement the Data Protection Act. So it was notified by the Minister of Electronics and IT, MeitY. So rules were introduced to operationalize the DPDP, that is Digital Personal Data Protection Act. So there are some key terms with respect to this. First one is data principal. Data principal is the individual to whom the data belongs. The individual to whom the data belongs or who is the owner of the data. Second is data fiduciary. Data fiduciary, that is an entity, a company, government, any entity that collects and processes the data. Then another term mentioned in the data protection rules is consent manager. Consent manager. So that is a platform. That's a platform or an intermediary that helps individuals manage their permissions, And the rule says that these kind of consent managers should be companies based in India. That is a mandatory no. It should be companies based in India. Now, what are the major rights for the data principal? Data principal, there are certain specific powers. First one is the consent architecture. Consent architecture, which clearly says that data cannot be processed without free, specific, informed, unambiguous consent. Free, specific, informed, unambiguous consent. So it should be for a specific purpose and it needs to be free, unambiguous. There should be very clear consent. So it should be clear, plain language. That is one thing. What are the reasons why you are collecting that particular data? So that is the consent architecture. Second, so that is the first one. That is the permission. Second aspect of the consent architecture is the consent manager. Consent manager, they will also have a role in giving permissions and all. Second, data principal has certain rights. Rights, first one, right to know. So right to know what data is collected, why the data is collected, right to know. Second, right to withdraw. right to withdraw, right to erase, right to erase, right to delete, right to erase. You can ask the company to delete your data if it is no longer needed. Erase. Then another key aspect of the consent is protection for vulnerables, especially children. It requires parental consent. And there cannot be shown any targeted ads. Targeted ad. Advertisements. Then data principle also should enjoy a mechanism for grievance redressal. Grievance redressal. For example, you can file a complaint to Data Protection Authority, that is Data Protection Board, DP, Data Protection Board of India. Companies' obligations, that is data fiduciaries' obligations. Major obligation of data fiduciary is breach notification. Breach notification to both the authorities as well as to the data principal without delay. Breach notification to data principal as well as data protection board. Yeah, without delay. Without delay. Breach notification. Similarly, they should not data minimization. They should not keep data for a longer period. They should use it for the purpose and then delete it. Data minimization and the deletion of old data. Plus another aspect of this data protection is that government, it empowers the government to seek any information from the data fiduciaries, to seek information from the data fiduciaries in the interest of national security, in the interest of national security. Similarly, state may process without explicit consent for issuing subsidies and benefits. For issuing subsidies and benefits, state may process the data without explicit consent. And the authority which will oversee the act's implementation is Data Protection Board of India. And there will be heavy penalties. Now some MCQ traps here is, the act does not specifically explicitly talks about right to be forgotten. What it says is right to erase or eraser. Right to eraser or right to be forgotten. It does not explicitly talks about right to be forgotten. Right to be forgotten is explicitly mentioned in European Union's General Data Protection Law. European Union's General Data Protection rules, it is mentioned. Right to be forgotten, but in Indian case, it is not mentioned. Similarly, cross-border data flow. It generally allows cross-border data flow except, so there is a negative list, except explicitly restricted by government notification. It generally allows cross-border data flow except explicitly restricted by government through notification. That is, government will maintain some kind of negative list. Appeals from the board's decision. Board's decision, appeals from this or against this board's decision will be heard by a tribunal, that is Telecom Disputes Settlement and Appellate Tribunal, TDSAT. Telecom Disputes, TDSAT, Telecom Disputes Settlement and Appellate Tribunal. So this here's decisions of the data protection boards, appeals from the data protection board. Telecom Dispute Settlement and Appellate Tribunal. Next, another continuation of that topic is data protection. Handout is not there. क्या हो गया? दिखा दो. Huh? You did not get handouts. Acha. How many? This section did not get. It is intentional. You will get it. Okay. दे दो. So you should have told before itself. You are protecting your data. Now, so there will be negative list. Don't give to Pakistan. Don't give to Bangladesh. Don't give to. So you cannot give to those states which are explicitly notified by the government. So government will maintain a list, and government will say to this you cannot allow. Generally it is allowed. Means for all others it is allowed. Government don't need to notify which are the places it is allowed. Government will notify which are the places it is not allowed. दे दो, जल्दी दे दो. Data protection and RTI. So RTI basically provides right to know. Data protection gives citizen right to privacy. So this is the problem. So through the Data Protection Act, Parliament amended RTI Act section 8 subclause 1 subclause J. 8 subclause 1 subclause J. So I'll just read the exact provision of 8 clause 1. You just listen, you don't need to write and all, but just listen that. 8 subclause 1 exact verbatim from the RTI Act. 8 subclause 1 says that notwithstanding anything contained in this act, there shall be no obligation to give any citizen. So this is basically a protection available. And that is the 8 clause 1. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen. Now these kind of terms are important. Why? Because UPSC will pick up exactly from the bare act, original act, and will put that as a statement. under that J, original act, J says, information which relates to personal information, the disclosure of which has no relationship to any public activity or interest. I'll repeat that. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which could cause unwarranted invasion of the privacy of the individual, unless, there is a exception, there is a clause, unless Central Public Information Officer or State Public Information Officer, that is PIC, or the appellate authorities is satisfied that larger public interest justifies the disclosure of such information. You don't need to disclose the personal information unless PIC or the appellate authority thinks that there is a larger public interest in disclosing the information. So it's a very big, almost like a good number of words are there. Further, J also says that provided that information which cannot be denied to the parliament or a state legislature shall not be denied to any person. This is J, original act. After the amendment, now what it says, personal information could not be denied. No, that is not. Now it says that information which relates to personal information, that's it. Nothing else. 8.1 says that notwithstanding anything contained in this act, there shall be no obligation to give any citizen. After the amendment, now it reads 8.1 is that under that J is reading only this thing, information which relates to personal information. Means previously under the section 8.1J, the PIC can deny the information. When he can deny the information? If it is a personal information. And this personal information is not having any connection with the public activity or public interest. Or revealing this information is basically an unwarranted intrusion into his privacy. Plus it was also giving a protection to PIC. What was the protection? How he can ensure that what are the things which I can give? Otherwise there won't be any protection, he will be liable for everything. So further J also says that information which cannot be denied to parliament or state legislative assembly or state legislature cannot be denied to any person. So that he can take a decision, okay, this is an information which I can give to parliament, so I can give this to the people also if there is a larger public interest. So this was a clear section where it says that if there is a public interest you give the information, if not, don't give the information. And how you decide? If you can give to parliament, you give that. So this gives a clarity to the PIC, as well as if there is any public interest you will get that. Now all this is gone. 8.1J says that information if it is personal information. So now PIC won't give any information, because the problem is that personal information can be two types. One is natural personal information, or what is personal information definition under DPDP Act. Natural persons is what? Poor people, we people. But DPDP says that it is not just individuals, it also include, Hindu undivided family, companies, everything. Legal persons, that is also included. This means nothing will be now, will be disclosed, because it all comes under as a personal information. This is a challenge now. So this topic we discussed in our mains class also. Again relevant for your PT, the facts. So what are the basic facts here? Section 44.3. Section 44.3 of the DPDP Act, 44 subclause 3 of the DPDP Act amends section 81J of Right to Information Act. And thereby limits 81J to information relates to personal information. It deleted all that big passage and just gave what? 1, 2, 3, 4, 5, 6 words. Information which relates to personal information. That's it. Just 6 words now. Previously there were many words. Maybe like some UPSC aspirant, after limiting everything to 100 words, 150 words, 200 words, he thought that, hey, this is too much, I can cut it and make it personal information. So that is the problem, because, and also DPDP defines the definition of person not just as a natural person but also as a expanded definition for person. So these are the things in that. Next come to right to be forgotten, that we discussed, just we'll conclude the other aspects of that. So if you did not clear PT or mains, but after 1 or 2 attempts by sitting in CABA class and all you cleared. But if somebody search the name, then what is coming is that he did not clear 2-3 PT. It is affecting your marriage. Big reputational problem. Girls are having more choice now. Our overall sex ratio is also changing. Even in some states, sex ratio is changing. Girls are more than no problem. Less is the problem, right? Girls are getting more choice. Girls, if they see that in first search there is 3 PT did not clear, girls will say that. Even if you clear, girls will say that no. Otherwise also everything, marriage, everything is delayed. Nobody want to marry. Nobody want to save, nobody want to marry. Gen Z's, it is said, I am not saying, okay. So it said that like they want to have, somebody said yesterday, my rules, my life. My life, my rules. ठीक है? So poor old people will have such mistakes. Okay. So that is a problem. So internet is not forgetting that. You are having a right. What is the right? Right to erase. Right to erase means you are asking that company to erase that particular details. You are saying that okay, you remove my 3 not clear this thing. So the company is removing it, but still the internet database is still having that. So internet is not forgetting. So that right to forgot means a complete removal from the World Wide Web or overall source. So that is not there. Such provision is not there. Still it may be like still some of your data may be publicly visible in search engines or internet at large. That is a problem. What is available as per our law is right to erase. Now there is one more, it is a factual aspect but it is relevant. Supreme Court in Puttaswamy case judgment recognized that right to forgotten is also part of right to life. Right to life. But what is available as per the law, statutory provision, it is right to eraser, DPDP Act. But this right is there in European Union, because European Union, originally this right is of French origin. It is of French origin, France jurisprudence or French jurisprudence. You can trace this right to French jurisprudence where there is right to oblivion. That right is there in France. Right to oblivion is there in French jurisprudence. So that is basically utilized by former offenders to object to publication of their past offences, because now they want to leave. You did not clear PT, that does not define your future life, right? It's okay. But in your case, you should clear PT. You people, you are having that obligation to clear. If you are not clearing, that means it's only because you are not studying. There is no other reason. The problem is you are not able to devote time for UPSC. You are able to devote, and see, the main problem is you are not able to, like, that small device is the problem. I always used to tell that keep that device away from you. Use some, yesterday somebody was using Nokia phone, use that. Some old phones, use that, and if you really want to clear, you buy a new phone and give to your friend. You will clear. So, the problem, if you are studying also every 5 minutes, if you are picking up your phone, then there is a problem. Every 5 minutes, if you want to pick up the phone, in class also I am seeing it. Some are going like this with phone. The idea is phone only, no other natural calls. This personal call. This you should avoid at least for the next 5 plus 3 months. 5 months for PT, next 3 months for your means. 4 months. 4 months only for PT. Why? 110 days left. Very good. Every day counting and sitting, right? Personality rights. It is recognized as a part of, I think in that case one judge basically considered this as European Union and said that okay, this can also be part in the information age. Next is personality rights. So if you are famous, your voice, your face, your signature, your style, Durandar, everything will be. No. It is not. It is not. It is not. It is basically, see, there is something which is binding part. That is ratio. Another one is obiter dicta. So you cannot say that we enjoy right to be forgotten as a fundamental right. It is not there. It is acknowledged. That does means if you are having something, you can approach court. Court is saying that okay, forget is thing. No, it is not explicitly. It's not a fundamental right for India. If that is the case, automatically it will be available without DPDP. Now it's a statutory right under right to eraser. If there is a fundamental right, DPDP cannot come up with a provision which is less than that particular right. Personality rights. So if you are famous, your voice, your signature, your style. Very good. Okay. Salman Khan's everything. It will be, that is personality rights. This you know, right? So there are two things. Personality rights. So the right of an individual to control the unauthorized use of their personal attributes. Personal attributes. Like your name, image, voice, likeness, distinctive expression, everything. These are all part of the personality rights. And there are two key components. One is right to publicity. Right to publicity, that is the commercial side. Right to protect your image from being used to make money. That is right to publicity. It is often associated with Article 19 of the Constitution. Commercial side. Then there is right to privacy. That is the personal side. That is right to be left alone. That is not to have your personality represented publicly without your consent. These are the two components, right to publicity and right to privacy. Right to publicity is the commercial side, protected under Article 19. You can use the way you want, your face, your voice or anything. Or the next is right to privacy, which is the personal side. If you don't want any publicity, you want to be left alone, you don't want to be anywhere, then that is your privacy protection. Constitutional framework, so it is Article 19, Article 21, both part, freedom of speech and expression and right to privacy. Legal side, it is basically part of the intellectual property laws. Intellectual property laws, for example, Copyrights Act. Or Trademarks Act, Copyrights Act. Trademarks Act. This allows for registration of names, etc. as trademark, signature, all this. And also Information Technology Act, IT Act, which is there to address the issues of like digital impersonation, deep fake. Devika is not there. Devika is there. Okay. Devika is also sit here, right? Okay. Deep fake, impersonation, all these issues will be addressed through Information Technology Act. And it is also part of civil wrong tort. Civil wrong tort. So these are the way you can get it addressed. You can either, if you have some copyright protection, then you can use that. If you are having something trademarks protection, you can use that. If nothing is there, then you can approach the court and file a tort, a civil wrong, and you can get it addressed through the court. You can approach the court and you can get that as a civil wrong and you can get a remedy. So these are the possible things. Copyright, there is a law. What is important is that means there is no single law which protects personality rights in India. Western countries are having such laws which protects personality rights. In India there is nothing. India the option is basically it is a civil wrong. You can file a defamation suit and you can get it addressed or you can get a remedy. So these are the key aspects. Another key question is, does this rights last forever? In Indian case, this right does not last forever. It ends when the person dies. There is no posthumous right. There is no posthumous right. It ends when the person dies. So there is no specific law in India. And also there is no posthumous rights protection. It ends with the person's death. So these are the things with respect to this particular. There are Supreme Court laws, High Court's orders. Supreme Court, one significant law is Otto Shankar case or R. Rajagopal case, where Supreme Court recognized that individuals have a legitimate interest in controlling their use of identity. So privacy violations. But court also said that there is no prayer restraint. There is no, means you won't put any prayer restraint. If something is violated, then you can approach court, you can get it remedied. That is the key aspects. You got the distribute it fast. What is why there is a delay? You have to. You cannot approach Supreme Court for this. This is civil wrong. This is tort. So you can approach the normal court. You can get the remedy from there. Exactly. I am saying that. So while courts declared this, courts also clarified that satire, parody, or news reporting and news reporting, etc., are protected under Article 19, Clause 1A. Means free speech protection is also there. If there is a satire, like stand-up comedians, they'll get a protection if there is no such intention to defame or anything like that. Or if there is a cartoon, these are getting protection. These are also there. Okay. Next is menstrual health. So this is one of the landmark judgment in 2026. That is, the case is Dr. Jaya Thakur. Dr. Jaya Thakur, please idhar de do. Dr. Jaya Thakur versus Government of India 2026 case, Supreme Court landmark historic judgment in the starting of this year itself. That is, menstrual health is a fundamental right. Court ruled that menstrual health and access to menstrual hygiene management, MHM, menstrual hygiene management in schools is part of right to life and dignity under Article 21 of the Constitution. So the petitioner basically filed, Jaya Thakur, she filed a petition highlighting that lack of MHM measures, that is menstrual hygiene measures, led to school dropouts and absenteeism. So this is the case where court said that, so the constitutional scope of this is, first one is, it is part of Article 21, that is right to life and dignity. Court said that dignity is not just an idea. It means living without humiliation. It means living without humiliation. If a girl cannot access hygiene products, this is for your mains also. If a girl cannot access hygiene products, she suffers from stigma and humiliation. Stigma and humiliation which violates her dignity. That is the first one. For PT purpose, you just need to know that it violates right to dignity. Second, it violates Article 14. It violates Article 14 because of gender inequality in schools. If schools are not providing such things, then it creates a gender specific barrier. Gender specific barrier is created. This leads to inequality inequality, especially for like girl children. This leads to perpetuation of inequality. So it violates Article 14. Article 14. Third one, it also violates Article 21A. It also violates of Article 21A because government promises free and compulsory education. Government promises free and compulsory education, and if a girl drops out because of MHM issues, because of MHM, menstrual hygiene management issues, or such health concerns, it defeats the purpose of 21A. It defeats the purpose of 21A. And court also issued certain guidelines to schools to address the menstrual poverty. What is menstrual poverty? Lack of access to menstrual hygiene products. Court also issued guidelines to schools or strict directives to schools, which has to be implemented within 3 months in all schools. All. No exception for private, aided, unaided, nothing. In all schools, these rules will be applicable. What are the major things? One is infrastructure. Basic infrastructure like functional toilets, all those things. Hygienic disposal options. So one is infrastructure. Second one is products. Court said that there should be free products. Free products like OXO biodegradable sanitary napkins. So such a biodegradable napkins needs to be provided free. Disposable napkins. And third one, there should be an MHM corner. MHM corner. Every school should set up an MHM corner, that is menstrual hygiene management corner, which is equipped with addressing any emergencies. Addressing any emergencies. Plus, court directed that union government should formulate a national policy. National policy on menstrual hygiene management. Court also suggested curriculum changes. The main thing is that you need to educate boys and male teachers. So there you need a curriculum change. That is also very important, because the problem won't come from girls, problem will come from these particular sections of the population. They are only reducing the dignity. Next is right to be free from the adverse effect of climate change. This is not a new thing, but still it is relevant as I match the following or something, that is why. So Supreme Court in Ranjit Singh case, Supreme Court in Ranjit Singh case, for the first time recognized right to be free from the adverse effects of climate change. But do remember, this case was related to the protection of Great Indian Bustard. This came last year, GIB. Last year there was a question, no? Something related to GIB. What was the question? If not, it will come this year. Last year it came. This year it come. Last year also studied, right? So this year revise that. This will come this year. So that time you will sing that, "Arey Great Indian Bustard is a great." और बाकी कुछ नहीं जानता है. This will be one question. This is also one question. This is another question. Okay. This is in case. See, whatever we are teaching in class, everything is important. You cannot neglect. So that is the key issue that is related to the protection of Great Indian Bustard. In this case, court said that right to be free from the adverse effects of climate change is recognized under Article 14 and Article 21. Under Article 14 and Article 21. So 21 anyway you know. Right to life doesn't mean that animal existence. It is a dignified life. That also include, better environment, pollution free environment, better climate, all those things. So that is a dignified life aspect. It is not a life like an animal existence. What about Article 14? How it is related to 14? It is related to 14 because climate change impacts rich and poor differently. So there is an inequality between rich and poor with respect to the adverse impact of climate change. Because of that difference, it is violative of Article 14 of the Constitution. Next is Article 22. This is also a main topic I think we discussed. Such main topic will be relevant for PT both. So Article 22 talks about protection against arrest and detention in certain cases. Protection against arrest and detention. It talks about two things: punitive and preventive detention. Punitive and preventive detention. So punitive is what? First one, there is a offense. Then there is trial. And you have the particular offense has to prove beyond doubt in the court. Then there will be final detention or final jail term. That is the thing. So there is an offense created. This is the first place. There is an offense. In preventive, offense is a possibility. Offense is not the first one. But what is the first one? Detention is first. That's reverse of this. Detention is the first one. Why? To prevent a future offense. Prevent a future offense. And here the trial happens, here there is no such a trial. Person will be detained because of the fear of a future offense or to prevent a future offense. So first just brush up what are the rights, safeguards under punitive detention. That is someone who already committed a crime, and this will be under what? Ordinary law. This will be under special law. Ordinary law is what? The general IPC or like BNSS, those things. So what are the safeguards in the case of punitive where offense is committed? What are the safeguards for a person under the punitive detention? First one is what? Right to know. What is the right to know? Grounds of arrest. Grounds of arrest. He committed offense, he will be arrested, then the trial goes, finally he will be getting a punishment or the detention or whatever, if he is proven beyond doubt that he is committed that offense. Here right to know grounds of arrest, not just reasons of arrest. Not just reasons of arrest. So what is the basic difference between reasons of arrest and grounds of arrest? Reasons of arrest is general. Grounds of arrest is specific. Specific to that particular crime. Reasons of arrest is that, but is general aspects of that crime. That's it. That is why that particular person is arrested. But every case will have a specific things, that is the grounds of arrest. So right to know grounds of arrest. Second, right to a lawyer. Right to a lawyer. Consult and defended by a legal practitioner of choice. Third one, 24-hour rule. Yeah, excluding travel time. Big problem. Every class I used to listen this. If I told I say 24 hours, immediately sir, excluding travel time. Means maybe they will have experience also. Police might have taken them from Kashmir to Kanyakumari, then finally might have taken to Noida. So that may be the reason. Okay, anyway, so excluding the travel time. So that is 24-hour rule, you need to be produced before the magistrate. And fourth one is right to release. Right to release. If the magistrate does not authorize detention or authorize detention, the person must be released within 24 hours. Means police cannot keep a person in custody more than 24 hours. The exception to this is preventive detention. What are the safeguards? Yeah, here also it is precautionary in nature. There are certain safeguards. Here also he needs to be informed of the grounds of arrest. Informed of the grounds of arrest, but there is exception. What is exception? Here it is mandatory. You need to tell the grounds of arrest. Here if there is a security concern, national security interest, or if there is some circumstances which makes that no need to disclose that ground, then you can avoid disclosing the ground. So it is not necessary in all cases. If there is an involvement of national security concern, then you can avoid disclosing that. Next one is, here also there is an opportunity to make a representation. That is there. Third one is time. Here what is the time? Here punitive 24 hours, but in the case of preventive detention, Constitution says that detention cannot be beyond 3 months. This is in Constitution. But it is possible, exception is there. What is exception? If there is an advisory board constituted for that purpose, recommends further detention, or if there is a Law. Law can be made both by parliament as well as state. The matter is both in the union list and concurrent list. So law can be made by both parliament and state. If the law prescribes a further detention period, then you don't need to consult an advisory board. So otherwise we need to constitute an advisory board, high court judges and all. NSA, what is the maximum time period? Yeah, 12 months, 1 year. I think still 1 year is 12 months. Right, okay. Some people, Elon Musk is sending some people, planned to send some people outside and all. So there we don't know. Time, space. But here it is 12 months, NSA, National Security Act, maximum detention period is 12 months. So Parliament also enjoys the power, similarly state also enjoys the power to make. No. There is one more thing, there is a threshold. In the case of preventive detention also, Supreme Court through various judgment come up with a higher threshold for preventive detention. What is the higher threshold? Only if there is a grave threats that affecting community, only if there is a public order threat, not just a law and order problem. Law and order is the minimum thing. If you go out here, there may be law and order problem, because some people might not have returned their full notes, and the person will ask, please give your notes. Other person won't give. Privileged communication between me and that person. Then there will be quarrel. That is also a law and order problem. But that is not a problem to detain that person. Preventive detention. It should be a broader problem to the community, full team. Then we'll put that person in preventive detention. If you are having any such a problem, you can inform ma'am. She is in charge of preventive detention. Okay, so these are the things. Next one is armed forces. So Article 25. Armed forces. So Article 25 of the Indian Constitution talks about right to freedom of religion. What is 25? Yeah, there are 4 important keywords. First one is right to conscience. That is the first one. That is basically the inner freedom of an individual. That is right to conscience, inner freedom of individual to practice the religion or that. Second is right to profess. Right to profess. So if you believe in a certain particular religion, you have the right to openly declare that as your religion, belief. Third one is right to practice. Right to practice. Performance of religious worship rituals. Fourth keyword in this article is right to propagate. Right to propagate, transmission and dissemination. But it has to be, not forceful act, forceful conversion or anything is prohibited. But here what happened is that there is a case related to armed forces, and the person refused to participate in a normal ritual as part of their regiment, saying that it is violative of his right to fundamental right to religion under Article 25, that is right to conscience. So he said that I won't enter into the sanctum sanctorum, which is basically the ritual place of that particular regiment. So where basically they do some ritual and all. So Delhi High Court said that this is violative of his role as a military official and also invoking the provisions under Article 33 of the Constitution. Delhi High Court upheld the dismissal of the officer. The matter went to Supreme Court. Here also the petitioner argued that his fundamental right to practice religion under Article 25 of the Constitution could not be taken away just because he joined the armed forces. This is what he said. He joined the armed forces doesn't mean that his fundamental right under Article 25 to, what are the rights? Right to, what are the rights under Article 25? Conscience, profess, practice and propagate, that cannot be taken away because of fundamental right protection. Here Army's argument is what? Army argued that a commanding officer must be accepted by the men he leads, and these rituals and ceremonies are tools to boost the morale. So they are expected to participate to strengthen the bonds. So the matter was Supreme Court also 2025 case, Chief Justice and another judge upheld the officer's dismissal, which is the Delhi High Court's judgment. Upheld the Delhi High Court judgment which dismissed the officer. So the key observation is that Article 25 is also having limitations. Supreme Court observed that it protects only essential religious features, not every personal sentiment. It protects only essential religious practice. So that is court time and again talked about what? Doctrine of essential religious practices, or court basically used this test to see whether a practice is essential to your religion or it is a secular practice. Protection is available only if it is very much essential to that religion. Without that practice, the religion will lose its character. Only then it is considered as protected. So here also court said that everything cannot be protected, every person's sentiment cannot be protected, only essential religious features are protected. Plus court also said that the military necessity under Article 33 of the Constitution, military necessity or the power granted under Article 33 of the Constitution. So Article 33 puts restriction on the rights of armed forces. It puts a restriction on the rights of armed forces, Article 33. And this particular act of the Constitution empowers Parliament to restrict fundamental rights. Of members of armed forces. What is objective? Yeah, maintain discipline and proper discharge of duties. To maintain discipline and to ensure the proper discharge of the duties, this particular provision is provided. So that is a military necessity. So Parliament basically restrict the rights belonging to some specific categories. One is armed forces, that is Navy, Air Force and Army. Second one is, members with the responsibility to maintain public order like CRPF, police, BSF, all such paramilitary forces, central forces. Then there is also restriction on intelligence bureaus, officers, IB, RO. Then there is persons employed in telecommunication systems. This is important. This will be the trap. So members of armed forces, three forces, Army, Navy and Air Force. Second one is forces in charge of maintaining public order, that is police, CRPF or all those things, maintaining public order. Third one is persons employed in intelligence bureau, RO. Fourth is persons employed in telecommunication system set up for the purpose for any of the forces. Set up for the purpose of any of the above forces. So that is one trap. Second is only Parliament has the power to make laws under Article 33. And the law can, what is the status of judicial review? With respect to Army Act or such act, there is no, that such cannot be challenged in the normal court for the violation of fundamental rights. It can exclude the jurisdiction, it can be basically allow for court martials. So these are the things. Final topic, minority rights. That is Article 30 of the Constitution. Article 30 of the Constitution, that is right of minorities to establish and administer right of minorities to establish and administer educational institutions. So what is the right given? Establish and administer educational institutions. Second aspect of this law is minorities. Constitution does not define minorities. Constitution is not defining minorities, but they are identified based on religion and language. So here the article itself is having two important dimensions. One is the right is available only to minorities, that is the difference between 29 and 30. 29, though the word is used to minorities, it is basically open to all. But here it is saying minorities, and how these minorities are identified in the Constitution? Based on religion and language alone. Only these two categories. And what is the right they are getting? To establish and administer. Means they can set up and they can govern it. So this is the Article 30 of the Constitution. So two grounds, that is on religion and language, and 2 rights, that is establish and administer. Now another key aspect is that in the TMA Pi Foundation case, TMA Pi Foundation case, Supreme Court held that under this article, minority status will be conferred based on state. So within the state, minority will be identified. So that is based on the state, minority will be identified, and then they can establish or administer educational institutions. So this is basically Article 30 about. With that come to, this is also not a new thing, it is related to AMU, Aligarh Muslim University. So in this case, court come up with some core essentials of minority character. Core essentials of minority character. First one is, while the primary purpose of, it is given, you can just explain it, add the explanation. While the primary purpose of minority institution should be the conservation of language, it does not have to be the sole purpose. So it can be the reason for establishing, but it may not be the only purpose. It is existing only for that purpose is not the case. It can take up other things also, other secular education aspects or advancement, culture, all the other things. The only thing that it should not lose the minority character. Second, it can admit non-minority students. It does not lose its character merely by admitting non-minority communities. So non-minority students can also be part of that. Next is secular education. They can impart secular education. They can run like a normal college, school. Fourth one is government aid, religious instruction, these kind of aspects. So no student can be forced to take part in any religious instruction if it is government aided. But they may impart, minority institution can impart religious instructions. They can impart religious instructions. But you cannot make it compulsory. Next is, there are two important aspects, twofold test. To identify the minority character. See, there is a recall worksheet. So we'll, I think it is yet to be distributed, right? So what you are supposed to do is, I think I already explained it. What I am saying is that many are not doing it. It will look simple for you. Gradually we will make it more tough. Then you won't never attempt also, I think. But you need to fill this and keep it. Just after going back, revise, and then you fill these sheets. So there will be blanks, you just need to fill it. If you are filling it without reading it, that means you remember all the important points whatever we discussed. So that you need to do. It will be distributed. You can take it after, while going back you can take it, but you need to fill this. This is not like some, why I am saying it, some students are saying that let us do it in class. The problem is that if you are doing it in class, it will be a lot of chaos. Some people will go, some people will sit. So you take it, but you need to fill it. If you are not filling it, then you will have to sit here and you will have to do it from next class onwards. That will be mandatory. Because we are going through a privileged communication. So this is twofold test, that is establishment, that is who founded and what purpose, that is it. That is establishment test. What is the origin of the idea and primary intended beneficiaries of that particular idea, that is the first aspect. Yeah, who founded, origin of the idea, and what is the purpose of establishing it. Primary intended beneficiaries are minorities, that's it. Others can also benefit, but primary intended beneficiary is minority. This is the first test, establishment aspect. Second aspect is administration. Who actually controls it? Control over the decisions, who actually controls it? That means what is important is that minority communities founded the institution, but it is administering with a purpose of that, but maybe that administrator may include non-minority or non-other actors also. The only thing is that minority representatives are needed and they should reflect the minority interest. So it can have other things, for example, parliament come up with a law, that doesn't mean that it will lose the minority character. AMU, there was Aziz Basha case, like case and all. Initially it was said that okay, it was a minority character, then parliament come up with a law. Court said that there is no minority, then parliament come up with a law. Since it is a central law, there was a problem that since it is coming under central law, now there is no minority character like that. Finally, this is the final decision. Okay, so these are the key things with respect to fundamental rights. We finished with the fundamental rights. Now we'll move to 2-3 DPSPs are there. One is like, for example, Article 41 is the right to work. That is important because in the background of this Manrega and all, What? Yeah. Yes, what is it? No, they are. No, they are in separate law. They comes under separate law. Uttar Pradesh also. But there is a verdict by the Supreme Court which accepted that they can give certain they cannot give degrees like graduation degrees, but they can teach students up to 10th class or something, but they cannot award degrees which is only the right of UGC. So they won't come under the UGC. So those things which UGC can award, they cannot award. Otherwise they can teach students. There is nothing like that. Happened in I think 2023 or 4 that case was there. That is possible because it comes under an act. State will enact an act. That act gives a permission for this like bodies. What happened in Supreme Court case is that Supreme Court said that okay, you teach up to 10th class, no problem. The law is valid. If the law itself is not there, then they will come under the mainstream. But the law provides that. But court said that okay, you teach up to 10th class, but after that, degree and all is a UGC. This thing that you cannot give. That is only UGC having that like power to award. That you cannot give. So that power is cut. But it is basically, you can say, severability, doctrine of severability. Those which allows it is remain, other thing it is removed from that. That is it. Yeah. Yeah. No, see, guidelines are applicable only for schools because there is actually the problem happens because it is also related to 21. So Jaya Thakur said that that is why a petitioner said that there is a absenteeism and dropout. So court issued guidelines only to schools to prevent that because it is perpetuating inequality. 14, it is against 21 and it's also against bodily autonomy under 21. You gave interview, right? I said, okay, good. This year also.